Today, I want to clear up one of the biggest misunderstandings in rural and communal land matters in South Africa, and that is the difference between a PTO and a title deed. This is very important for people who want to buy land in rural areas. So, a PTO stands for permission to occupy, and this is very important because a PTO does not automatically mean that you legally own the land, nor does the person selling it to you own it. What it means is that you have permission to occupy and use that land. Understand that. So, in many communal areas, the land is held under custody of a traditional authority. You would know that, such as a chief and inkosi, and that authority itself may derive recognition from the government or a customary law system. Think about that too. So, unlike a title deed, a PTO generally does not give you full ownership registered in the deeds office. Yeah? Let's compare the two quickly. A title deed proves your legal ownership, that it legally belongs to you. It is registered in a deeds office and it can usually be sold formally and can be used as collateral in a bank for finance. Okay? A PTO, on the other side, or other hand rather, gives occupation rights. It is common in communal and rural areas. You don't really find this in towns. It's governed through a customary or traditional system, and it's not the same as registered ownership as the other I explained. So when people are selling land under a PTO system, it's usually just the rights being transferred and not the land itself. So the things that are transferred, as I say, is just the rights and obligations. Yeah, that's that's about it really, and whatever is on that land. So this is why these transactions are very different from normal property transfers involving title deeds. Okay. Does this mean that your PTO is useless? Of course not. Absolutely not. PTO holders have important rights and protections under the South African law. For instance, Section 25(6) of the Constitution of South Africa recognizes that people whose land tenure is insecure because of past discriminatory laws are entitled to legally secure tenure or have comparable protections. Okay, and one very important law here is the Interim Protection of Informal Land Rights Act 31 of 1996. It protects people holding customary land rights from just being evicted willy-nilly without following proper process. Authorities can't just bully you off your land. Another important law is the Upgrading of Land Tenure Rights Act 112 of 1991. This act recognizes land tenure rights, including permissions to occupy land, which is what we're talking about now, and in some cases allows upgrading tenure rights into stronger forms of ownership. Now, here are some important things I believe people should remember when buying land in rural areas. Make sure that the person selling the land has a PTO that reflects their details, their personal details on it. Secondly, involve by all means the traditional authorities. That means the chief or the headmen in a traditional council which are responsible for that area. Thirdly, always have a witness present. Very important. Number 4, put everything in writing. I seriously recommend that. Don't rely on, verbal arguments only. Lastly, maybe I can say make certified copies of IDs, copy the documents. Okay, maybe one more. Just keep proof of payments. So these are very critical for your protection when it comes to buying a land in rural or communal areas. The chief is very key. Having witnesses and being recognized by the community is very key. So I recommend highly, don't just conclude a deal between yourself and the person selling. Things can get tricky for you very fast.